Well, hello, I'm Philip Harris, and welcome to this, the third, I think, in the series of Law Bites, which we're doing virtually. And this one is from the Wright Hassall construction team, obviously, and it deals very briefly with practical completion and the significance of practical completion. So practical completion is in some ways less important than it used to be when I was a young man, because in the old days we didn't have partial possession. Partial possession is the process by which the employer can take over parts of the works as the job goes along. So if he wants to get his income stream out of a particular apartment or whatever, he can take over parts of the works. In the old days, we didn't have that. So it was an all or nothing situation. You had to get to practical completion. If you didn't achieve practical completion by the contract completion date, there would be liquidated damages, and there wasn't this business of partial possession under which the employer could take over the relevant part and then liquidated damages reduce and the retention he holds reduces. So it is sort of toned down, the significance is toned down to that extent, but it's still very important. And the crucial thing is that the JCT contracts don't define what practical completion is. It's like the small boy and the elephant. I may not be able to describe an elephant, he says, but I know one when I see one. And that's exactly the approach that the JCT and ultimately the courts will take, where there's no definition of practical completion. Now you can put in, clever lawyers will put in definitions of practical completion into contracts, and that can be disastrous. And they will often put in wording like when there are no apparent defects. And then you've got to ask yourself, well, what does that mean? I can hear equipment making a nasty noise, but I can't see any defects. So are there no apparent defects? Is apparent, does that mean visually obvious, or does it mean something else? So you get tied in knots as soon as you start to define what you mean by practical completion. So building contracts are complex, and the moment at which practical completion is achieved, the significance of practical completion has to be looked at in all the circumstances of each project. The meaning derives from its significance as a particular point or stage in the process. It's a milestone and it's a watershed in building contracts because of its position relative to the contract's completion date. If the works achieve practical completion after the contractual completion date or any extension of it, then the employer will be entitled to liquidated damages. If practical completion precedes the contract completion date, there's no liability for liquidated damages. So if you remember your Dickens and Mr. Micawber, I've got sixpence in my pocket, happiness, I balance the books, happiness, I'm short of sixpence, misery. Practical completion is like that. If we bring it in the right side of the contract completion date, fine. If we go over, we've got the misery. If the contract provides for liquidated damages, we're paying liquidated damages. Obviously, if the contract is overrun and practical completion then occurs during the overrun, that will immediately bring to an end the liability for liquidated damages once you've got to practical completion. Insurance is another significant thing. In quite a lot of building contracts, it depends on the insurance option that you go for. But in quite a lot of contracts, the contractor has to insure the works, and he insures the works up to practical completion. So practical completion is the point at which the insurance flips over and passes from the contractor on the one hand to the employer on the other. And retention, the first half of retention in a conventional contract, will be due for release at practical completion. The JCT contracts haven't always defined clearly and well the precise moment at which the retention becomes payable, but basically the first half of retention is due for release at practical completion. And it marks the beginning of the rectification period, what we used to call the defects liability period, the rectification period, rectifying defects. It kicks that period, which may be, depends on the contract, but maybe a year off. It starts that period running. If the works don't achieve practical completion by the contract completion dates, then under a conventional with architects, traditional with architects contract or contract administrator, the architect or contract administrator must certify non-completion straight away. If it's a design and build contract, then the employer's agent will state that the works have not achieved practical completion. And at that point, if the employer wants to, he can deduct liquidated damages, but subject to 3 triggers. The first is the non-completion certificate or statement itself. Then, under a typical JCT contract, the employer must notify in writing that he intends to deduct liquidated damages. And then on top of that, because we're in the Construction Act era, he must serve a pay less notice setting out the basis of calculation of the liquidated damages that he's deducting and that he is deducting them. So it could be 3 weeks at £3,000, £9,000 liquidated damages I'm going to set off under this contract. Now, it can't be overemphasised that if you are a subcontractor under a subcontract, then you must notify practical completion. There is no business there of the architect or contract administrator certifying practical completion. You go to the main contractor in writing with your notice and you say, I believe I've achieved practical completion. And then if you don't get a written dissent within the prescribed period, let's say 14 days, then practical completion is deemed to have occurred. If you do get a dissent, then practical completion is achieved when the parties agree it's been achieved. But if they can't agree, then the conventional position is that practical completion of the subcontract will be achieved when practical completion occurs under the main contract. And of course, if you're a ground worker doing your work in the first 6 weeks of a 2-year contract, you might be waiting a long time to get practical completion under the main contract. Now, just to touch on practical completion and liquidated damages and set-off. If you are, again, under a subcontract, what the main contractor will want to do is to take both liquidated damages which he has to pay under the main contract and other damages. So it may be, if you're at the beginning of the contract chain as a trade, there are 15 following trades, and they will all, if you delay them, they will all claim against the main contractor. So he wants to be able to claim liquidated damages, which are passed down to him under the main contract, but also these other losses that he's incurring under the subcontract. So he will put in the subcontracts, in the particulars, he will say that I'm paying, I'm going to have to pay 10,000 liquidated damages a week if you cause me to overrun. Now, what can happen then is that let's say the ground worker at the beginning of the process does overrun, and the main contractor says, well, okay, I'm going to pass, I think I'm going to be in delay now. I'm going to pass on to you the liquidated damages which I will incur if I am in delay under the main contract. And there is a case, a fairly old case now, Chat Brown Limited against Alfred McAlpine Construction at Southern, which is 35 building law reports, so quite an old case. And that is a Court of Appeal decision, and it says that it's quite strongly arguable that the main contractor has no right to take liquidated damages, to deduct them from the subcontractor until he is himself in delay under the main contract. So he has to wait. If the subcontractor delays him in March, but his completion date is November, he has to wait until November, until he's in actual delay, before he can start taking liquidated damages. And that's an important point, a kickback for subcontractors to raise, where they get the pay less notice saying you're subject to liquidated damages under the main contract. One way of looking at the situation, this balance between practical completion and contractual completion, or the extended contractual completion, is to see it as a seesaw. If the contractor is in delay, then the seesaw comes down on the side of the employer and he takes liquidated damages. But if the contractor is delayed through no fault of his, through a relevant event which entitles him to an extension of time, then he, in turn, the seesaw comes down on his side, and he, in turn, then wants to be paid his time-related prelims. So the time-related prelims, it's important that the contractor states in his tender what his time-related prelims are and how they're calculated. So much for hutting, so much for supervision, etc. But if he can establish that he has, let's say, approximately £3,000 time-related prelims per week, then he can take his time-related, or he can claim his time-related prelims because of the overrun. So if the employer delays him, then he gets his prelims. If he delays the employer, then he pays liquidated damages. So if you haven't got a definition of practical completion in your contract, then you've got to look at the case law, haven't you, to see what the judges have said practical completion is, what they've said in the past. And most people find their way to a couple of cases. One is called Emson, E-M-S-O-N, Eastern, as in the east of the country, against EME Developments Limited, which is 55 BLR. And in that case, Judge Newey confirmed his own earlier judgments in the case of Neville Sunblest against William Press, where he'd been looking at what the Court of Appeal and other courts had said about practical completion, and he tried to distill it all. And he said that practical completion could be certified where very minor, de minimis, tiny little amounts of work had not been carried out. But if there were patents or obvious defects, practical completion could not have been certified. And he also said, importantly, that practical completion is completion for all the purposes of the contract. And there may be situations where the contractor can make use of that phrase and say practical completion is completion for all the purposes of the contract. Now, one of those situations is quite difficult to get your head around, but one of those situations relates to where you've got to practical completion, you've achieved practical completion, but the employer turns around and serves a pay less notice and says, well, I'm not going to pay you what would otherwise be due at practical completion because I reckon there's £100,000 worth of defects. And that can't be right if you look at what Judge Newey was saying. If practical completion is where all but tiny little defects have been put right, then there's no basis for the employer to be deducting, very substantial sums for defects. So it really precludes the levying of substantial set-offs for defects. Now, On the other hand, if after practical completion a defect comes to light in the rectification period, then even though an amount has been certified at practical completion, it would then be possible to do a pay less and say, well, this has come to light after practical completion. So that's what you need to check. But there are situations where, without any obvious coming to light of new defects, monies are withheld. And the answer to that, practical completion, is substantial evidence that those defects don't exist. Another point to make quickly is that it is bad practice to certify practical completion with a list of substantial defects. Now, we're in the real world. Employers want to get their income stream out of their buildings, whether it's rent or whatever, and pressure will be put on architects and contract administrators to certify practical completion and then do a big list of snagging with substantial items. But the textbooks, Keating and Hudson, are very clear that that is bad practice. I just mentioned the case of William Tompkinson and others against the PCC, Parochial Church Council of St Michael, which comes from Construction Law Journal, Volume 6. And in that case, a contractor was really trying to sort of swing the lead. And he said that there had been this defect which had arisen before practical completion, but it hadn't been picked up. It hadn't been picked up and raised. So you had a situation where practical completion had been certified, but there was a substantial defect. And the contractor, as I say, tried to be clever, and he said, well, look, the rectification period, the defects liability period, is to put right defects which appear in the rectification period. So we only have to put right defects that appear in that period. We don't have to put right this defect, even though we know it exists and even though it was there before practical completion. And the judge was having none of it, and he said, no, the wording means that if a defect is apparent in the rectification period, then you have to put it right. And then that does give you an argument for saying, well, I can certify practical completion with a list of substantial defects because you've still got to put them right in the rectification period anyway. Look at the Tompkinson case. But honest answer to that is that leading textbooks, the leading authorities, are fairly clear. You do not certify practical completion with a substantial list of defects. So all the case law I've looked at so far is, pretty old standard stuff. I'm speaking in the COVID era in 2020, and obviously there's not been a lot of new case law this year. So I'm going to a case called Mears Limited, M-E-A-R-S, Mears Limited against Cost Plan Services Southeast Limited. And this is March 2019, so in COVID terms, not all that long ago. And the Court of Appeal there gave guidance on practical completion. It didn't really say anything particularly new, but it did go over it all. It said practical completion is easier to recognise than to define. There are no hard and fast rules of what is or isn't practical completion. Practical completion cannot be prevented by the existence of latent defects. You have to know there's a defect to hold up practical completion. You have to know it's there. So a latent defect, something you don't know about, won't hold it up precisely because it's unknown. There's no real difference between an item of work not having been done, being outstanding, and one requiring rectification. If it's an item that requires rectification, it's simply a bit of work that hasn't been done yet, so there's no substantial difference between the two. They said, confirming the situation, it's a state of affairs, practical completion is a state of affairs in which works have been completed free from patent or obvious defects, except trifling ones. Whether an item is trifling is a question of fact and degree. legal authority that because an item cannot be remedied, it's irremediable, as they said. Practical completion cannot be certified. So you've got to get to the stage where you've got tiny little defects left, and that's practical completion. If those defects can't be remedied, they just simply can't be put right, and that won't in itself prevent you getting practical completion. So that is just a quick run through the basics on practical completion and how it works, and I hope that's been helpful. Thank you very much.